I, Afreen Kalaso, am the Assistant Director for University Engagements and Partnership at LSAC Global. It is my honor to welcome you all on this very special day to the LSAC Global webinar on the topic Constitutionalism, Idealism versus Realism, organized by LSAC Global under the Discover Law campaign. On behalf of our team, I would like to thank the panelists and our audience for the continued support and dedication towards enhancing access to legal education and increasing the diversity of legal profession. Before I start, I would also like to inform our audience that we have an exciting announcement at the end, so stay tuned till the very end. In case you want your friends to join in, please ask them to register for the webinar. On that note, I would like to share the theme of today's webinar with a quote by Dr. B.R. Ambedkar. That is, Constitution is not a mere lawyer's document. It is a vehicle of life, and its spirit is always the spirit of age. Today is the Constitution Day, also the National Law Day or Samvidhan Divas. The day is observed on the November 26th every year to mark the adoption of the Constitution of India by the Constituent Assembly in 1949, which came into force from January 26, 1950. The Constituent Assembly took nearly 3 years to draft the Constitution. The drafting committee, chaired by Dr. B.R. Ambedkar, was given the task of preparing a draft Constitution of India. Today, we aim to celebrate this day with some interesting questions on making of the Indian Constitution. Often, law schools touch upon constitutionalistic ideas and the rule of law. However, since the adoption of the Indian Constitution, the concepts have gone under a transformation. The aim of the webinar is to revisit some of these theories and understand the future of constitutional rights in India. Today on our panel, we have some eminent members from the legal fraternity who have made significant contributions in law. Let me introduce you to the panelists. We have Dr. Aman Hingorani. Dr. Hingorani is an advocate on record at Supreme Court of India and has argued cases on diverse fields of law before the Supreme Court, including the Constitution benches, various high courts and tribunals in the country. Several of these cases have been reported and have led to a change of law. Dr. Hingorani is also engaged in teaching law and professional skills development since 1998 as adjunct faculty and is an international advocacy and mediation skills trainer. He has taught constitutional law, human rights, mediation, arbitration, and international trade law, amongst other subjects. He also runs training programs for students, law teachers, lawyers, and judicial officers. Thank you so much, Dr. Hingorani, for making for today's webinar. Next on panel, we have Dr. Purvi Pokhriyal. Dr. Purvi is the founding Dean of School of Law, Forensic Justice and Policy Studies at National Forensic Sciences University. She specializes in the area of criminal justice studies and justice education. Dr. Purvi holds a master's degree in law with a specialization in criminal law and a doctoral degree in constitutional law. She is also a visiting faculty at HOF University, Germany, and is a resource person at various training programs, national and international conferences as well. She has also been the editor of many academic journals. She has also conducted various FDP programs for law teachers on innovative pedagogy for law teaching. Thank you so much, ma'am, for taking out time for today's webinar. Next, we have Dr. Nusrat Praveen Khan. She is the Dean, School of Law, Bennett University. Dr. Khan has held a position of former Dean, Faculty of Law at Jamia Millia Islamia, New Delhi. Her PhD on the topic Legal Control of Air Pollution Problems and Perspectives were awarded a publication grant by the Indian Council for Social Sciences by the Ministry of HRD. She has also authored dozens of books on conflicting and contemporary legal issues. To name a few, women and child-related laws, comparative constitutional law, and of course, on the legal control of air pollution. Thank you, ma'am, again for joining us for the webinar. And last but not the least, we have Dr. Saurav Mandel. Dr. Mandel is an associate professor at Jindal Global Law School. He holds a PhD in law from National Law School, India University, Bangalore, for his research over the impact of family jurisprudence on queer lives in India. His writing sits mainly on the junctions of law and society, gender, sexuality, and governance, global queer movements, and law reforms. At JGLS, he teaches constitutional law, legal methods to undergraduate law students. In addition, he also offers an elective course titled Queering Kingship, Family, Intimate Relations in Law, Theory and Practice that is offered to students all across the university. Thank you again, Professor Mandel, for joining us today. Now, as you know, this is a fireside chat. I would be asking questions to the panelists. It'll be more of a conversational style. I also request the audience to write their questions in the Q&A section as we commence, and we will take those questions at the end of our fireside chat. So let me begin with the first question, and this is something I would want all the panelists to address before we delve deep into our conversation. And I throw this question to Dr. Aman here, that what does constitutional mean in simple words? And how do you relate the Indian constitution and current issues, the issues we are facing today here in India?
Thank you, Afreen, for the introduction. Good evening to everyone. Well, in popular discourse, constitutionalism basically means, or it's the antithesis to an authoritarian regime, the notion that sovereignty rests in the people, a common person on the street, not a despot. So as a society, we need a government, and a government comprises of people, but we can't really trust people. Human beings being vested with authority must be restrained by something more potent than their notion of fair play and discretion. And so we frame a constitution. So a constitution basically is actually a symbol. It's the most marked symbol of distrust of human beings and human nature. The purpose of constitutionalism, which is supposed to be within the constitution, is to somehow balance the rights and freedoms of people on one side and put limitations on the powers of the government on the other. Coming to our constitution was not on a clean slate. We had before us in 1947 the experience of the Successive Government of India Acts, particularly the 1935 Act. And those acts were meant to serve British colonial power. We had examples of other constitutions like the American Constitution, the Irish Constitution. And so our Constitutional Assembly, as you rightly pointed out, labored very hard to draw up a constitution to meet the aspirations of our society. Our society was a fractured society. It was reeling under partition, the horrors of partition, effects of colonization, inhuman poverty, and so on and so forth. So it was in that backdrop we have this constitution to transform from colonization or colonial country to a free state, to self-governance. And so we insisted on government by the constitution, sovereignty of the people, democracy, separation of powers, judicial review, fundamental rights chapter, directive principle of state policy, military to be under civilian control, independent election commission, so on and so forth. So that is one aspect of constitutionalism. The other is that in any free country, the constitution must evolve. It's organic, because it actually embodies the moral sentiment of the people, and these sentiments keep changing from time to time. And so the constitution has to, it's been said that a constitution should be like clothes. It should be made to fit the people it's meant to serve. So we have seen the development of constitutionalism through different constitutional amendments. So this would be the kind of a popular notion, but for me, I feel, and I'm sure there are many others who will share the same sentiment, that there's much more to a constitution than just constitutional provisions which are there. Mere constitutions don't make a country constitutional, or political parties don't make a country a democracy. Constitutionalism also means imbibing the spirit of the constitution, of fair play, of justice. And that is being inculcated both by the citizens as also the state. Constitutionalism is to be safeguarded by rule of law. It's not ruled by law. So if we talk about citizens, Common example is we see people jump traffic lights because there is no traffic policeman watching. But we should not do that, not merely because it is violation of the law, but it goes against the spirit of orderly traffic that is meant to ensure equal exercise of rights for everybody, whoever's commuting. Coming to the state, if you talk about recent issues, significant laws like the farm laws should not be pushed through ordinances during a pandemic. That would violate the spirit of democracy. The courts can't put habeas corpus petitions or constitutional challenges to electoral bonds or abrogation of Article 370 on the back burner. That would detract from the spirit of judicial review. So more than the concrete provisions, it's also the spirit, the underlying spirit behind that constitution, which is important. It's not on the merit or demerit of any particular constitutional challenge. I'm on the manner in which these issues are addressed, because is that consistent with constitutionalism? So we may have an excellent constitution, but a constitution is only as good as the men and women who give effect to it. So if you're talking about the Indian constitution, the implication for India, broadly speaking, this is what I would understand by constitutionalism. And my emphasis would be more on internalizing every individual, whether in government or outside government, internalizing the concept of fair justice, of all the points you've talked about in their daily life. It should be a way of life. We should not be spitting on the streets. It's as simple as that. It doesn't need to be big things. It could be very, very small things. So those small things, according to me, is what is more important when we talk about constitutionalism.
Thank you, Dr. Aman here, because I think it's important to understand that constitutionalism may sound like a vague concept and something which cannot be implemented, but it is something which you and I as citizens can, adhere to, and that as a collective effort, as a society, we can move ahead and ensure that that spirit is lived and touched upon. Again, I would actually direct the same question to Dr. Purvi. You've been somebody who's actively worked on different research papers regarding criminal justice studies. How do you think one can relate that to constitutionalism and that spirit? And how do you think it's different from that?
Well, thank you, Afreen. At the outset, let me convey my best wishes for the Constitution Day to all the panelists and all the presenters, the audience over here. Well, when we talk about constitutionalism and then constitutionalism in the context of the criminal law, I would say that, there may be many countries who may have a constitution. For that matter, there may be, most of the countries would have a constitutional text, but there will be very few who would be adhered to the principle of constitutionalism. So in the narrower sense, constitution we know as an arrangement of the governance. It talks about the power, functions, and limitations of the government. But at the same point in time, when we talk about constitutionalism, it is something which it talks about the limitation and the exercise of the power of the government, and that government necessarily to be a representative government. Now, representative government here means it could be a representative of one individual, it could be a representative of an overwhelming majority, it could be a representative government of an elite, it could be a representative government of the poor class. But then every government and every powers of the government is subjected to some kind of a substantive limitation. So basically, constitutionalism talks about the doctrine of limited government. So no matter overwhelming majority government may adhere all the principles of the lawmaking faithfully. No matter they may be representing the real will of the people, but there are certain substantive limitations through which they cannot beyond certain, they cannot beyond go with certain, with reference to the exercise of such powers. Now, when we talk about the constitutionalism in the context of criminal law, we have been talking, and discussing and deliberating at number of platforms that it is a high time that we need to look at all the criminal laws with the principles of the with the lenses of the constitutionalism. It is a high time that we need to constitutionalize our criminal laws, because there are certain fundamental freedoms and liberty which are being guaranteed by this pious document. How this liberty are being compromised with the kind of laws that we are making in the name of the what we call it a law which is required to maintain law and order in the society. So there are a lot of issues with the existing framework of many criminal laws, wherein we need to carefully revisit the constitutional principles. And at this juncture, I'm reminded of a great, the father of the Indian Constitution, Dr. Ambedkar. So when he was talking about the Constitution of India, he emphasized on two very important rights. He used to say that this citizenship provides you the bundle of rights. And there are two most important rights which he talked about. The first being a right to participate in the representative formation of the government. And second, right to be the part of the formation of the government. Now, these are the most two important rights through which you can take part in the governance system. And in that context, being an ordinary citizen or being a common man, what how would you contribute with reference to upholding the ethos of the Constitution? What as a common man or as an ordinary citizen we can do, and that important power lie with everyone is the power of being the part of formation of the government. So I do agree, the criminal law and the criminal justice delivery system has to be, each of the aspects, each of the procedure has to be carefully woven and revisit with reference to the constitutional ethos which we are having, and we need to look at whether we are adhering to this constitutional ethos and constitutional morality. Thank you.
Right, Dr. Purvi. I think you make a great statement here, as how Dr. Hingorani was talking about implementing it into day-to-day life, how constitutionalism also has its effects on the criminal justice system here in India. Which actually brings me back to Dr. Khan here, because I believe when it comes to the concept of constitutionalism, and when you're teaching that to law students, I would want to understand that how is it important for law students to appreciate the Indian Constitution, and what are those history sort of teaching the students in terms of how it's formed, the Indian Constitution. So if you could throw a little bit of light on that, I think it will really help the audience today.
So good evening to all of you, especially LSSC team, as well as Dr. Aman Himangorani, Professor Purvi, Professor Saurav, who happened to be my student once upon a time. Yeah, so good evening, and a very, very warm wish with regard to Samvidhan Divas, that is the Law Day. So finally, the topic which you are floating is a very, very relevant topic in today's context, especially on this day, as well as while we are talking about the Constitution and its relevance. So with regard to constitution of a country, generally a constitution seeks to establish its fundamental or basic or apex organs of the government and administration. And it describes their structure, composition, powers, principal functions, interrelationship of one organ with the other organ. It also regulates their relationship with the people, and more particularly, of course, political relationship. So while you are saying about the students who are studying the Constitution and its relevance, definitely it goes into, it gives them the basic understanding of the governance as well as the principles of the working of the Constitution. Our Constitution, it came into force on 26 January 1950, way back, it's 72 years. And it was an ambitious political experiment. We know that our Constitution is a result of lots of research by the framers of the Constitution and drafters of the Constitution. They thought of the best of the principles of different constitutions of the world. We say fundamental rights we took from US Constitution, or directive principle from Ireland, more so, and some very specific and conspicuous, things about universal adult franchise, the federalism in a region which is consisting of a large number of princely states at that point of time. And of course, the social revolution in the deeply unequal society which we are living in. And over and above, as it is already said by the previous speakers, a country may have constitution but not necessarily constitutionalism. It means a lot. A constitution is just a document describing all describing all those organs and their functioning. However, constitutionalism, the term even does not find any explicit mention in the textual document of the Constitution. Nonetheless, its impact and influence are entrenched deep within the philosophy of our, Constitution and all the institutions which have been established there under. Even the Supreme Court, if I go to the past and even the latest situation, have very often used this term frequently. The first case where the Supreme Court used the term constitutionalism was in the state of Jammu and Kashmir versus Trilokinath Khosa case. I mean, it is a very old case. Constitution of any country is a living document, and the outlook and expression which are perceived and expressed by the interpreters of the Constitution, they must be dynamic and they keep pace with the changing times. So it is not a static document. It's to keep pace with the present scenario, with the future time also to come. Fundamentals, however, of any constitution, they are unalterable. But the interpretation of the flexible provisions of the Constitution, which is accompanied by the dynamics of the Constitution, modern political thinkers, they tries to draw a distinction between constitutionalism and the Constitution. And when we say the idea of constitutionalism, it is, as I said earlier also, it's not a new concept. It is embedded deeply, and it has been, promoted, this idea has been promoted through various writings of the various philosophers also. If we look at Locke's writing, Grotius, Rousseau, so they all mention somewhere the concept of a good constitution or a good document or a good society with rule of law, separation of powers, or fundamental rights, lots of elements which we can say. It is most importantly independent judiciary and powers of the judicial review, and fundamental rights provided, decentralization. These are some of the basic principles which promotes the principle of constitutionalism in any country. So somehow to say when all these elements exist, it connotes the essence of limited government or limitations on the government functioning. Constitutionalism basically is antithesis of arbitrary powers. It is basically that we know that power corrupts, and absolute power corrupts absolutely. So all those authorities, all those powers given under the Constitution should not be misused, should not be taken for granted. So how the principle of constitutionalism, with the help of some of the basic limitations, and the insistence that these limitations be placed on those powers which has been given to the authorities, because unlimited power leads to an unauthoritarian oppressive government. It is, geoparadizes the freedoms of the people. Now, if you said, when we are understanding to what extent we are able to achieve ideally, when we say Constitution's goal or constitutionalism. So at the first blush, idealism and realism may seem intuitive. They are easy to grasp concept. The idealism basically sketches the ideal principles that it assumes people will comply with. It idealizes the state of affairs by assuming every extant conditions such as social strife, law breaking, or scarcity of resources. In that sense, all the favorable social conditions, those that are necessary for the working of idealizing conditions and fostering cooperation among the people. Idealizing, idealism concept is a type of blueprint of the of whatever we understand. It's a type of vision. It sets a vision, a goal for the society should be striving for. So once we have outlined the ideal principles, we can figure out by outlining non-ideal principles how best to revise our political and constitutional practices so that they will direct us towards the ideal, given our less than perfect conditions. We know our conditions also, we know our politics also. So all that our constitutional ideals presumably they had there in their mind while they were writing the constitution. At the time the existence of later on, constitution came into existence, we got independence, then the existence of political disagreements, different political parties, elections, new ideologies, and lots of internal and external conflict and tensions that besets the political life, and they have gotten away from whatever notions of the ideal we had at the outset. So often the constitutional interpreters, especially I'll talk about the courts actually, they are working to bridge the gap between idealism and realism. They're trying to bridge the gap. So I'll say judiciary, an independent judiciary, if you look at the different judgments given by the judiciary, they are playing a very, very important role while upholding the constitutionalism and rule of law. It is a very important prerequisite to create and sustain it, constitutionalism, which refers to range of ideas and patterns of behavior, how the government should be regulated in its power. At times, judiciary goes beyond to its jurisdiction also in the name of judicial activism. So there is a very important role. I hope if I'm given again opportunity, I will be highlighting lots of judgments, rather plethora of judgments, whereby through the judicial dictums, the judiciary have played an important role in upholding the constitutionalism, whether talking about, constitutional morality or social morality in some of the judgments, or talking about, Justice Gogoi talking about idealism and, realism of the constitutional document. Yeah,
Sure.
thank you.
Thank you, ma'am, for that. I think that was a really comprehensive sort of a download as to what constitution really entails. I'll just quickly move to Professor Mandel here, because I feel if you could also give the audience a bit of a background as to what is the most intriguing fact of the foundation and the historical evolution of the Indian Constitution. I think that will give us a good basis as to how the concept has changed over a period of time.
Yeah, sure. Thank you so much for having me over here, and very good evening to everybody, especially my teacher, Dr. Khan. It's a privilege to share, I think, this panel with you. Thank you so much. So I think with respect to, I think, when we sort of understand the making of the Constitution, I think your question basically takes us back into the history. And I think it's very important for us to understand history, not just from its dominant narratives that has set the history, but also from the alternative and sub-discourses within the larger discourse that also constitutes what we understand as history, right? So what we often see missing from the dominant narratives of the making of the Indian Constitution are the tussles and conflicts within the minds of the makers of the Constitution that is often kind of ignored. I mean, if you look at the dominant writings, which are sort of being taught in the law schools as canonical textbooks, I don't need to mention them, I think, but we all, I think, intergenerationally, we have been sort of, I guess, a product of that upbringing, you know, when we kind of spend our 3 years or 5 years in a law school studying constitutional law and other sorts of laws. So I guess the dominant narrative sort of it hides or it completely ignores those conflicts that were there in the minds of the makers of the Constitution, the realities that they were confronted by, which I think Professor Khan she sort of tangentially, she was referring to And that is important in the law schools, that we sort of bring that discourse or these sub-discourses within this, broader dominant or the non-dominant narratives of the making of the Constitution. So I think there are two models that we need to understand. When we look at this discourse of making of the Constitution, the first and the dominant model is the consensus model, which sort of is highlighted by, canonical authors like Granville Austin, for example. One of the authors who has sort of from the beginning witnessed the making of the Constitution, has written from his lived experiences of being, at that point of time. And I guess the idea of a consensus model of understanding the history of the Constitution of India is that it is a lot of, I guess, a kind of a patchwork to an extent, because we borrowed a lot from other different parts of the world, different constitutions. It's a sort of a kind of an understanding that we also inherited the colonial legacy of the legislations that we had, like the Government of India Act 1935, for example. And it is often then kind of pushed or passed as a notion that, okay, the Constitution of India sort of allows that constitutional legislative legacy to sort of continue beyond 1950, right? Which is also true. There is no denial on that account. Article 372 of the Constitution, it does exactly that. It assures that all your colonial laws are going to be the laws in force in the independent India, right? Having said that, I guess what we ignore are all those conflicts and a series of conflicts that have been unresolved in the past and also are unresolved even today. And it is inevitable, right? For example, the conscious rejection of the due process clause in the making of the Constitution. Why did the makers of the Constitution debate the due process clause, but then did not want to include the due process clause? And then later on, the Supreme Court of India in 1975, with the Maneka Gandhi judgment, it picks up that and revives the due process clause as a part of the fundamental rights and Article 21 of the Constitution. And now today, if you look at the Article 21 and all the jurisprudence that has come post Maneka Gandhi judgment of the Supreme Court, it celebrates the due process clause. And that's a very, very important part. Right. Having said that, for example, right to privacy. This is also something that was debated, but was consciously rejected by the makers of the Constitution. So I guess making of the Constitution has to be looked from alternative discourses of history. That's number one. I guess number 2 point, which we often ignore when we look at that founding moment of the making of Indian Constitution, is this very important gender aspect of this. I guess we often use this dominant discourse that, oh, the forefathers of the Constitution, B.R. Ambedkar as a father of the Constitution, which is perfectly fine. I guess Dr. Pokhriyal just brought that. In fact, which is also true in many possible ways, and that is great. However, we often, I think, ignore the 15 women members of the Constituent Assembly who also were a part of the making of the Constitution and have contributed immensely. However, that could be debated at various levels. But I guess if one looks at the works of Ramachandra Guha, if one looks at all these alternative histories, especially feminist writings on the Constitution, on the making of the Constitution, we see the role of these 15 members and the kind of background, the socio-economic backgrounds that they were representing, right? For example, Annie Mascarene, who came from a Latin Catholic community and from Kerala, was the first woman to have an education from a community. And similarly, there were Dalit women, but there were also affluent women from, representing the very dominant castes and dominant groups. There were minorities in that sense in various ways, in terms of religion, in terms of caste, but then it was a confluence of different, that diversity within women who also contributed to the making of the Constitution, right? So I guess that is important. The last thing that I would like to highlight is the aspect of making of the Constitution when the historiography is kind of, charted out, the chronology of the events. We often look at it from a very, I think, sort of a phenomena that started from 1940, let's say 1945 onwards, right, with the election of the members of the Constituent Assembly and the constitution of the Constituent Assembly, and then the partition of India, Muslim League members leaving, some staying back and joining the Congress, becoming a part of the Constituent Assembly. That is a formal historiography of the making of the Constitution. I think it dates back to at least 150 years, at least, so to speak. And if you look at the post-colonial authors like Sumit Sarkar, for example, I think they will tell you about, or Rohit Dey for that matter, I think historians like Rohit Dey who would tell you that, it all started with Raja Ram Mohan Roy to a great extent 150 years ago, right? And that new intellectual class at Calcutta and also other major urban centers where rights were discussed, the idea of rights within the empire and also against the empire, right? I think that was a very important sort of set of founding moments for the Indian constitution making, because it was bringing all that rights discourse within the people, right, in the media. And of course, that one can always debate that was sort of highly restricted to probably an English-speaking intellectual class. However, at the same time, we also see Tilak's Swaraj Bill in 1895, the Declaration of Rights adopted by the Congress in 1918, at the time of making of the Government of India Act 1919, So, and the Motilal Nehru Committee report of 1928, I think. We often sort of ignore that history also, right? I guess we need to sort of bring in all these discourses to sort of, bring forth a more, I guess, a more comprehensive idea of the making of the Constitution.
Thank you, Professor Mandel. I think you make a fabulous point in terms of introducing the gender aspect of when we are giving the due regards to the making of the Indian Constitution, because it actually brings me to Dr. Purvi here, because it's an important aspect to discuss. Dr. Purvi, you are a leader in your community and legal academia. How do you think it's important for women to continue and grow their presence in law and the lawmaking process? Because Dr. Mandel, he made a brilliant point as to we often forget the contribution of other committee members when we are talking about the making of the Indian Constitution. Now, after 75 years or so, how different it is from that time and now, and what do you see the changes happening in the future?
Well, thank you for this question, and I really appreciate Dr. Mandel to bring these 15 women into the forefront in the discussions when we are talking and celebrating on the Constitution Day. Well, I do feel that, being there, keeping the women in the forefront of the lawmaking process or maybe in the part of the governance is something which is the most empowering process, not only for those women who are being considered for a particular position, but for so many thousands and millions of other women who can see that women as a role model. And that gives that instill a different kind of hope, energy, and different kind of an inspirations in them. So I do feel that women representation, though women have always been considered as subaltern classes, and the way in which there are a lot of things that is being already written, and even we talk about the reservations, the special reservations for the women representation in the parliament. I am not very convinced with the idea of the women reservation, but you provide an ample opportunities, ample space and fair and just treatment to grow and develop to the women, so that they meaningfully contribute in the governance, they meaningfully contribute as a legislatures. The other day, we were discussing about the representation of women in the Indian judiciary. We had a great debate that how many women are there as as a part of the judiciary. We had a lot of data that is being already available. We have only handful of people, or handful of female who could reach to the Supreme Court. So do we really need a special reservation even in the higher judiciary or the apex judiciary? So frankly speaking, I'm not saying that there should be a reservation, but at least there should be a fair treatment. There should be ample opportunity. There should be a very conducive environment, not only at the home, but even at every aspects of the public life, in the school, in colleges, the kind of a motivation, the positive inspirations, and through which we can positively try to bring women participation in every aspects of the governments, and that is the need of the hour. I'm very thrilled to see that now when we talk about the legal academia, and of course, in the number of law students that we are getting in the law schools, and we are very glad to see almost in all the classes every year, we have almost 45 to 55% ratio, the gender ratio that we are observing. So many female that are now coming forward, and even their parents are reposing faith in them, and they are taking admission into law schools, and they are going to be. So I am very hopeful for the 20 years down the line, the scenario is going to change drastically, and I am hoping that there will be a good amount of women would be there in the legal profession, including all levels of judiciary. Thank you.
Thank you, Dr. Purvi, for those comments. I think you make a great point here, especially when it comes to contribution of women. I do want to direct a similar question to Dr. Hingorani and, plug in another question there, because I know for the fact that the women in his family have made great contribution when it comes to their success in the legal fraternity. So Dr. Hingorani, would you want to touch a little, base there? And then we can also talk about the issues which you spoke in your book relating to the Kashmir issue and how constitutionalism sort of creeps into that concept. And then we can take the conversation forward.
Well, I've been surrounded by strong women all my life. Starting with my mother, who was actually spearheaded not only many women movements. She was born in Nairobi, first lady from a community to go to UK for higher studies. Studied at Cardiff in 1947, came to India, and could not simply relate to how the two Indias we talk about, where one side you worship women, on the other side you have these kerosene stoves which used to burst, leading to dowry deaths. There's nothing called an Indian woman. You are either Hindu woman, or a Muslim woman, or a Christian woman. So she couldn't really come to terms with that. But then she had a strong emotional reaction with the undertrial prisoner's case. When we talk about constitutionalism, I think that does not exist in our country, because you can't keep people in jail for 20 years without trial. You can't keep people, victims of crimes, in jail because you need them for trial, to give evidence in trial. You can't have children being born and brought up in jail. So according to me, PIL, Professor Saurav was talking about due process. Maneka Gandhi brought procedural due process. Substantive due process came in with Hussain Khatun undertrial prisoner's case as a reaction to the breakdown of our system. PIL is proof that our system of governance doesn't work. It's not a sign of a healthy system, because if our system worked, we didn't need PIL. So when you talk about the role, it was her emotional reaction, which has been talked about by Professor Bakshi and many others, how she decided, of course, my father drafting the first petition and she arguing it. They worked as a team. And that led to evolution of PIL. And then I have my elder sister who's also taken to her footsteps and been in the profession. When my mother joined the profession in 1961, she was the only third lady lawyer in the Supreme Court. Today, we have a far better proportion representation of women lawyers. So we have come a long way. So, and that's a very positive sign. So I still say we need more women on the bench, not necessarily because they'll work for women issues, but each gender brings their own perspectives, and that enriches the debate. Coming to the book, you see, my research on the Kashmir issue, we started in 1995, and the book came out in 2016. Research 20 years has led me. The book is all about why the Kashmir issue has not been resolved till date, the longest standing dispute. And one of the reasons is the propensity of the government of India, right from 1947, to act beyond its constitutional limitations. We've been talking about the whole idea of constitutionalism is to keep the organs of the state within their limitations. The primary reason has been that our government, for whatever reasons, simply has had legally misconceived policies and acted outside the jurisdiction right from 1947. And I can just give you a few illustrations about that. Prior to the Indian Constitution, the constitutional law in force was the Government of India Act 1935 and the Indian Independence Act of 1947 that created modern day India and Pakistan. Now, this constitutional law, which created modern day India, mandated that as far as the princely states were concerned, the two-nation theory was not applicable. It was the sovereign ruler who could decide on the accession. There was a monarchy. We had 560 odd princely states. It was a sovereign ruler who could decide on the future of his state, accede to India, Pakistan, or stay independent. I won't get into the history of it that the ruler didn't want to come to India or Pakistan as far as Jammu and Kashmir is concerned. But eventually, the ruler did accede unconditionally to India on 26 October 1947 in the manner prescribed in that constitutional law, which is accepted both by India and Pakistan. And so Jammu and Kashmir became an integral part of India. It remains an integral part of India. Yet, our government, the government of India, for the historical reasons are given in the book, said we'll view this succession as being purely provisional and subject to the wishes of the people. The question is, did New Delhi have the power to lay down a policy which is contrary to the constitutional law? Could they lay down a contrary policy that accession will be decided by the wishes of the people? For the other 560 states, it was not. For Junagadh, Hyderabad, it was ratified by the ruler. By doing so, New Delhi overlooked the basic proposition that an executive created by the constitutional law could not act contrary to the terms of that law. A state cannot, by making promises, clothe itself with authority, which is inconsistent with the very constitution that gives it birth. But the fallout of New Delhi's misconceived stand is that the entire state is supposed to be disputed territory. It is New Delhi which gave disputed territory tag on Jammu and Kashmir, not Pakistan. And the fallout of that is that, and of course the book discusses what we can do to remove the disputed territory tag, but we have Indian territory, we are in possession of about 40%, 30% is about 35% with Pakistan, rest of it China, so nothing to do with the matter. Instead of recovering our territory, I've talked about how the book talks about yet another illustration how New Delhi acted beyond its constitutional power. They followed a policy of territorial status quo right from 1950s. That means we keep what we have, the others can keep what they have. So we disown not only our territories, we disown our people who happen to be citizens of India. As per the Constitution of India, people in POK are Indian citizens. Even they've lost their identity as being Indian citizens. We have disowned them. Which government disowns? I mean, that's why we are laughing stock as the world is concerned. But implicit in this policy is that New Delhi can cede national territory. We had Berubari Union's case, which says cession of territory is essential attribute of sovereignty. Every country can acquire territory, cede territory. But we have a controlled constitution. Later in Kishan Bharati's case, the Supreme Court has said unity and territorial integrity of the country's basic structure. That is repeated in Bombay. If that is the case, can India cede national territory today? Can we convert LOC into the national border? If not, we are barking up the wrong tree. So yet another instance of how policymakers or bureaucrats or foreign service simply are following policies which is against our own constitution. What do we do or follow of this? Focus only on the part of the territory with us. We dilute Article 370. We abrogate Article 370 in August 2019. 370 is not the genesis of the Kashmir issue. It's not the solution does not lie in it. Abrogating 370 and making Jammu and Kashmir into union territories won't get back POK. It won't get back our people. Our focus is only on the part of the territory which we have. And to maintain peace, what do we do? And of course, I've talked about how these moves are constitutionally vulnerable. But according to me, the 370 is irrelevant as far as the Kashmir issue is concerned. But what do we do? To maintain peace, we enact draconian laws like TARDA, ASPA. Again, the book examines how these laws are on the face of it unconstitutional, but upheld by the Supreme Court. Our security forces did not create the problem. They don't have a solution. But the political masters have said, maintain peace. That leads to human rights violations. Human rights violations of everybody concerned. Security people who come from rural India who did not create the problem, they're martyred. There are families which are destroyed. They're used as fodder. The innocent civilians are caught in the crossfire. And then the people who feel that injustice has been done, they want to pull things down. So you have, in the process of having laws like ASPA, POTA, TADA, what are we doing? Our constitution is a very liberal constitution. It's a human rights centric constitution. By upholding the constitutionality of these penal laws, drastic laws, we're changing the flavor of a constitution. We forget that laws do not persuade just because they threaten. A law with any state with defective laws will have defective morals, defective constitutionalism. And so the book discusses this in many other constitutional areas. I'm conscious of the time. There are many constitutional areas that the book talks about that all tie up to show how important it is for the state to act within constitutional limitations. Because if you don't do that, one misstep, one wrong policy will lead to many other problems. And so in that context, I would say that the book, I mean, of course, the book is a broader issue about going into British archives as to why we had partition, how partition was scripted, how the United Nations was subverted, the international politics, the whole thing about the Great Game, and how our eminent political leaders of undivided India were taken for a ride. And it is the entire subcontinent which still suffers. So it is a broader issue, but the best way of depoliticizing a particular issue or a conflict is to subject to a legal scrutiny, to see the legal underpinnings. And law can play a very big role in trying to resolve the Kashmir issue. And the book, of course, goes on to how to go about resolving the issue. That's a different debate altogether. But I'll stop here since I know the others would also need some time to share their thoughts.
Thank you, Dr. Hingorani. I think you touch upon various aspects when it comes to various issues we've been, sort of struggling since our independence, and it's something which is still ongoing, right? There hasn't been a sort of a solution which has come up. It could be varied reasons as to why that's not happening, but it's important to discuss it, and it's important to deliberate on these issues, specifically for a law student here, because as lawyers or as law aspirants, we somehow lose our focus, and we're always trying to understand how to get better jobs, placements, etc., but we don't really appreciate these nuances when we are in law schools or when we graduate from law schools. So I would be throwing this one question to all the panelists. I request you to take about a minute or so, then we can quickly move to the Q&A section, because we have really good questions coming up and I do want the panelists to address it. So quick one, and Professor Mandel, you could sort of start on this in terms of how can law schools reinvent when it comes to teaching the Indian Constitution, and why is it really important to be talking about it? And how do you see that sort of change coming in the next 10 years, that this would be an important subject matter to discuss, and how it is creeping in different niche areas, whether it's right to privacy or, the surveillance issues coming up, or, the whole pollution aspect of, the people suffering. How do you think the various aspects could be covered through the study of the Indian Constitution?
Thank you so much for that question. I think it's a very, your question sort of, I guess, it's a very broad question. However, I would like to sort of restrict myself a little on that. I think what we need to, there are, of course, I think as Advocate Hingorani very clearly had said, I think that not everything is in its right place, right? I mean, the system to an extent is sort of broken. So, and that is true. We need to acknowledge that. I think that's very important. So we need to understand that depoliticizing law, which I think Dr. Hingorani was sort of, kind of putting on in a certain context, which I understand. I suppose. I think it is important to understand that law and politics are very importantly, they're integrated. And what we teach in the law schools is just the law, the bare law. I mean, look at labor law. It is taught, for example, or look at for any other, I guess we don't have a critical, we don't look at law from a critical standpoint. We don't question why this law was there at the first place. Why did it come at the first place? Abrogation of 370. What are the political reasons for abrogation of 370? And then we can debate. Once we understand that why question and that how question, I guess, then we can sort of take it further. So I guess it's very important to sort of look into different critical scholarships to address different branches of law, whether that be labor law, for example. A feminist critique of labor law is very important. If it is constitutional law, I think we need to ask the question why senior advocate of the Delhi High Court, Saurav Kirpal, has not been appointed as a judge of the Delhi High Court, being recommended thrice, in the past. And what are the reasons for it, or what could be the possible reasons for it? And we need to, I guess, equip our law students to sort of with a set of tools to sort of understand, conceptualize, question, I guess, what is taught or what is generally considered to be something unquestionably supposed to be unthinkably, imbibed, accepted. So I guess we need to sort of give the law students, I guess, those set of tools to sort of question a lot of things and critique, and then understand that how and the why question of the law. So I guess that would be sort of, I guess, a sort of a comprehensive way to, I guess, change or kind of, I guess, queer the way legal education works in India. Yeah.
Thank you, Professor Mandel. Over to you, Dr. Khan, if you could just give us a quick outlook as to how law schools are reinventing when it comes to the teaching of the Indian Constitution and correlating it to the everyday life.
Yeah, so while they study the constitutional law, definitely they understand some of the fundamental principles, some of the important things under the Constitution. Simultaneously, it also entitled the students their duties and obligations apart from application of rights and values. But as right now, Saurav, while he said about, talking about fundamental, the way it is being taught in our law schools. Yes, I fully agree with him. In fact, while, I was a very junior teacher at Jamia Millia Islamia, I always used to tell my students in the class that we teach you judgments, but our judgment is, for example, 3:1 majority or minority or whatsoever, or any judgment which is saying so. Later on, another bench of the higher courts overrule it or upheld it further. So why don't you yourself at your front sometime question? For example, before it goes to the court of law, you also have a right to disagree with particular judgment or particular law or particular interpretation of the law. But that is not the way we are actually teaching in our law schools. So regarding that, the understanding of the students of whether it is constitutional law or whether it is any other law, it remains basically what is written in the books. It is not that critical approach or their own feeling. Sometimes even if they feel, but then they have to write in the exam, they will write in the exam like this itself. So the approach, I think we need to change. And then the students not only understanding with regard to the subject, but simultaneously, they will be, going into the drafting debates and then their own present day debates with regard to constitutional jurisprudence, as well as it can be with regard to other subjects. This is my take on this question.
Thank you, Dr. Khan. Over to you, Dr. Purvi. Would you want to share your thoughts as to how you have reinvented in terms of introducing different pedagogies when it comes to teaching the Indian Constitution in law schools?
Thank you for these questions. This is something which which is very close to my heart, because I remember at this juncture, our Professor N.R. Madhav Menon, who always used to say that there is only one document, there is only Indian Constitution wherein the legal profession is being categorically mentioned. So when we talk about Constitution, the most important thing which I would like, I have been promoting in all the law schools wherever I have been, that why do we need Constitution? What is the ultimate purpose of the Constitution? So, and then we start thinking, reading the fundamental duties, and the most important fundamental duties is to develop a scientific temper, spirit of inquiry and reform. From there, you would try to look at each aspect of the Constitution with a sense of inquiry. So it's all about the inquiry-based learning. So it's not only making a law and politics, but it's all about looking for every aspect and every actions of an individual, a collective action or an individual action, with the systematic scientific inquiry. So as a citizen, how do we develop that spirit of inquiry and reform? This is something which should be the first lesson in the Constitution. And then we start reading the Constitution. And the ultimate purpose of the Constitution is serving to people. How do we achieve this objective? How do we reach to the unmet justice needs of the thousands and millions of people in this country? So access to justice and linking with the upholding constitutional ethos and rule of law is the ultimate purpose. And these kind of interactions, these kind of communication in every provision of the Constitution that we are dealing. So each provision is to be tested on the touchstone of the constitutional ethos and for the purpose for which the Constitution was being enacted. So these kind of orientation and sensitization, it is something which is very much required while dealing with constitutional law. Thank you.
Thank you, Dr. Purvi. And over to you, Dr. Hingorani, specifically because you are also teaching at various law schools. How do you integrate that in your teaching?
No, I completely agree with the speaker that we need to change our teaching methods. We need to contextualize the way, to contextualize every judgment. What is the philosophy behind it, etc., and so on and so forth. But I can offer at least 2 or 3 concrete suggestions as to how to go about doing it. One is that we need to build a culture of judicial audit of superior court judgments. Every country, in most jurisdictions, you have organizations which evaluate each and every judgment of a superior court. If it's good, give the credit. If it's not, take it to pieces. Our judicial academies will never do it because they're controlled by the judiciary. Our universities, our law professors who should be, the reason why they're given less number of classes is that they get into this auditing, but I rarely see good papers or analysis coming out in the public domain. They may be internally, but not in the public domain. There's no reasons why students can't be asked to do a judicial audit of every judgment. So that could be one. The other is borrowing from the practices which is there. For example, in the Cardiff Law School, you have the Innocence Project, where students are asked to work on cases of gross miscarriage of justice under the supervision of faculty. Is slightly different from legal aid, clinic, etc. But here's a case where the principles underlying a given case is discussed. It's a kind of a teaching method where the faculty takes upon an actual case. We can actually get into the courtroom, get into the courts to get certified copy of the papers, help brief the lawyers who are actually appearing for that person who is a victim in that particular case, and so on and so forth, or person who's been wrongly jailed. So we can talk about that at another occasion, but they are modules of where students can get a hands-on experience. And third, there's no reason why law schools can't tie with other schools to teach. I mean, our time there used to be a civics paper. I'm sure they must be teaching constitutional law right from 8th standard, 9th standard onwards. There's no reason why law students can't offer the services there. In the process, they internalize the kind of principles we've been talking about. So there are many ways by which we can reinvent ourselves, not only the way we teach, but actually do concrete, do service to society by reaching out to the civil society and to the laws, to the junior schools and so on and so forth.
Thank you, Dr. Hingorani, for those comments and suggestions. I really hope, law schools do reinvent when it comes to teaching the Indian Constitution. So we are, I know, a little ahead of time, but I do request the panelists to, save 5 minutes more to address the Q&A section, and then we can close for the day. So I have a couple of questions, but I do find one question really intriguing, and I think all of you could address it. That is, what if one of the Constitution makers takes rebirth and comes alive and see what's happening, and what has been done by the Constitution? What would be their reaction? So, I mean, Professor Mandel, would you want to go first and address this?
I I don't want to put it as a very cliche, I guess answer, but I guess we cannot really neglect the three warnings that Dr. B.R. Ambedkar gave at the closing of the making of the Constitution. I think the three warnings were, number one, that very importantly, that there is no place in a constitutional democracy. There is no place for popular protest. Now, this has different parts. Okay, in a constitutional democracy, the idea of satyagraha and going for, I guess, sort of a kind of the Gandhian methods of protesting were not necessarily considered by Ambedkar as the most constitutional methods of, I guess, dissenting. However, I guess this in the current circumstances needs to be really relooked. And I think given that the majoritarian forces are so strong in the current circumstances, also in the past, in the 1970s, emergency, or we have instances from the past. I guess we really need to understand right to dissent, right to protest has its own place. And it's very important in any constitutional democracy that our institutions are strong enough. And I guess if not, then the people have the right to really speak up. This chilling effect that is happening in the society, I guess that needs to reverse change, I guess. So Ambedkar's warning, I think, will be very relevant in today's circumstances. And we need to rethink Ambedkar on this first aspect a little, if you like. The other thing Ambedkar said at the closing is about the unthinking submission to a cult of personality. And he was talking about hero worship, how we sort of go around this cult of personality about one person as the, inheritor of political legacy of a certain, and we have that the Gandhi Nehru legacy. We have currently going on the cult of personality around one person as the supreme leader, of the country. And that is going on. And we are seeing how this is going on. So I guess Ambedkar must be, I guess, really shocked to sort of see the way it is continuing intergenerationally, this cult of personality. And he warned against it. He said that unthinking submission to this cult of personality must not be the case in New India, in this constitutional society. The third thing he talked about is the paradox between political democracy and social and economic democracy. He said that although we are becoming a political democracy after 1950, 26th of January, and everybody in law, in the eyes of law, has equal rights. So formal equality is there in the Constitution. Everybody under Article 14 is equal before the law. Great. However, he then brought the aspect of the real need for equality, where you have social inequalities unbound, and I guess we have not been able to sort of resolve this paradox between formal equality and real substantive equality. So I guess looking at the current scenario, I think when you talk about the current socioeconomic indicators, of course, it has changed a lot. I think when I was growing up as a law student, I was very difficult. It was, I thought for that moment that I think between 2004 and 9 that I was studying my law as an openly gay, law student, it was very difficult to express myself. And what was the need to come out of the closet? It was to negotiate with I guess with the hegemonic, the setup of heterosexuality all around. Like, it was very difficult to negotiate with that within a law school, where actually law schools should have been very liberating, for law students. I now see my students, and I've been teaching for the last 8 years, and I now see my students, I guess they have really, the experience that they find in law schools today are very different. Although my experience could be deeply limited to only working in a few law schools probably, and I'm sure there are millions across different other law schools in semi-urban, rural, and other places, in India, where probably it's the same struggle that probably many like me probably are still facing coming across. So nonetheless, I think things have changed, but I guess we need to really look at, I guess, what Ambedkar would respond, at least from this framework of these three warnings. Yeah, thank you.
Thank you, Professor Mandel, for that. And the next question is something which has been popping up in various forums, is regarding the question of reservation and the reservation being made on economic grounds, right? And we know for the fact that how that historically has been changing ever since the Indian Constitution was adopted. So Dr. Hingorani, would you want to address this, that there is our audience members are asking that what is the actual reason for not adopting reservation on an economic ground, because there's a huge economic disparity when it comes to the people in the Indian citizens. If you could just address it. I know it's a bit controversial at forums like this, but we do need to understand the major reason behind this.
Well, I mean, it's not only the question being controversial, it is a very complex issue. So I may not be able to do justice to it by just giving a statement or of a few lines on it. But basically, when we're talking about reservation, the basic idea behind that was that a person suffers some social stigma. It's not necessarily economic. And a person can be outcast because of a particular caste from they come. And so for that reason, you do need to be able to do formative action so that that person is able to compete. The counter to that, of course, is very well, once that person has reached a particular stage, then do they need crutches all the time? Why can't they compete after having got the initial benefit? Or if one generation has got the benefit, what about the next generation? So there are pros and cons of it. The general principle which has been adopted by the court is that if out of every 100, if we do reservation should not exceed, I mean, there are different kind of reservations, horizontal and vertical. For example, you will have reservations on different grounds like handicapped or differently abled, etc. That should not be more than, say, 3%, 5%. I mean, that would be a different kind of reservation. But caste-based reservation, if you have, or for the OBCs and SCBCs, that should not normally exceed more than 50%, though there's no strict rule that it can't exceed depending on a given situation. For example, in a tribal area, you might want to have more than 50%. So if you can justify it, why not? And then to ensure it goes to the actually people who want or who deserve it, you exclude the creamy layer. And then that's yet another debate. How do you define the creamy layer? And then which generation, all that. So it is a very complex issue. There's, but the reason why economic criteria alone has not been found to be a factor to give reservations across the board. I mean, the way, of course, you exclude the creamy layer and you try to see if in that context, economic factor becomes one of the reasons also, is broadly speaking that it is a social attitude that needs to change. And that is what has been pushing forward. Of course, there can be debate on both sides, where one side will say that by recognizing caste, you're perpetuating caste. And on the other hand, the counterpoint can be that if you don't acknowledge there's a caste issue, then those people will never be able to get out of the circumstances. So, you know, so it would require a longer debate for me to do justice to it. So I would just leave it at that.
Thank you, Dr. Hingorani, for that. And thank you for addressing it, quite honestly. A quick question here, and I would actually throw this to Dr. Purvi, that, you know, the question is, how often should the state or the central government amend and revise the constitution? Because when we talk about constitutionalism, there's sort of a limitation when it comes to putting limitation to different powers in these three pillars, whether it's the judiciary or the executive or even the parliament. So do you think amending the constitution time and again sort of diffuses the essence of constitutionalism, or it is like a power given to the people there?
Well, it's a very intriguing questions. I can say that there is no fixed number which we can arrive at, that, you know, you can have these many constitutional amendments, or in a year you can, you know, a particular government of the day can pass these many amendments. I just would like to say one last line over here with reference to the constitutionalism, that when the countries like us, when we are embracing the democratic constitutional democracy, I would say the constitutionalism is expressing democracy's distrust in democracy. This is something I would like to say in a nutshell. So constitutionalism, no matter we have a constitutional democracy, but when we talk about adhering to the principles of constitutionalism, then constitutionalism is expressing democracy's distrust in democracy. And that's the reason that we can't come out with a specific number that with which, you know, only these many constitutional amendment that is being required to be done by any government in a year. Thank you.
Thank you, Dr. Purvi. We'll just take one last question, and this is towards Dr. Nuzhat. This question comes from Mr. Akram. He asked, has populism threatened the rule of law in India? I think we can have a nice conclusion around this, and we can close the webinar after this question. Thank you.
Thank you for the question. And the question is, does populism threatens the democracy?
The democracy or the rule of law?
I don't think it is the correct thing if a person is thinking, because we live in a system where democracy and voice of the people prevails. If we take it in the right context, this is by the people, of the people, for the people. Maybe at times, people's voices are being stopped or they are being suppressed, but it is not a threat to the democracy. It is, in fact, if taken in a positive sense, it is an addition. In fact, it is the people's will. Our constitution is not a static document. It's a growing document. And when we say growing document, it means it is things coming from the people, the needs and the aspirations of the people to be fulfilled with the help of the constitution in a democratic setup. So it is not a threat to the constitution in any way, as far as I understand. And I'll just take one line with regard to the previous question with regard to amendments of the constitution. So amendment of the constitution, again, something very positive. It is not in any way is harming to the constitutionalism. Rather, it is a type of achievement of those idealism in the real sense. Because whatever comes, where the realities are different, whatever, when the constitution framers idealizes certain postulates, certain principles, not everything has been achieved or can be achieved as such in any perfect society. And we have, and every society, I understand, have some of the other limitations or defects. So accordingly, the amendment is one of the way while we can improve upon ourselves. And that has happened in the constitution. If we look at, be it, taking Article 21A by incorporating free and compulsory education, or by incorporating free legal aid in Article 39A, or similarly many other addition, or maybe it is, Panchayati Raj addition in the constitutional law book. There can be many more, articles which have been added. So all towards a positive side of it, all towards the achievement of that idealism and to make it more real. Thank you.
Thank you, Dr. Khan. I think Professor Mandel, you would want to add something here?
I just wanted, I guess, on both the questions, I guess the last two questions, thank you so much. I think everybody, especially I think Dr. Khan has already summarized it. But I would like to sort of just address, I think, this last question about populism. I think we need to understand, how do we define populism? And it's a very broad and quite a vague political, theory. I guess we need to look at it. If populism turns into ethno-nationalism, I guess then there is a problem. The way our citizenship and our notions of Indian citizenship in the constitution have been shifting over the last 75 years. It started with this principle of jus soli, and it is going towards jus sanguinis, the way ethnic or probably religious or probably some kind of a sort of a legacy works to determine whether you are an Indian citizen or not. And that legacy in this case would be if you are a Hindu or not, perhaps. But that's not the text, that's a subtext of the law, right? And which has become the text of the law after the 2019 CAA, the Citizenship Amendment Act. It has also been the case with other citizenship amendments in the past, in 2004 and 2005 and otherwise. So I guess that there we have a problem with populism overriding, I think, So that's one thing I would like to address. In other words, muscular majoritarianism or ethno-nationalism is a threat to any constitutional democracy. And if populism is what these two terms signify. The other thing about the last question, about the previous question about, I think, need for amendments, I think, and it's a very broad question. And the idea is, I think that idea of constitutionalism must go beyond, I guess, the idea of changes in the constitutions. And this is, I think, reflected in the French constitutional history. If you look at it, France has had 5 constitutions between 1791, the first constitution, and then 1958, I think, the last and the current constitution. But the idea of rights, that has not changed, rights of the people. That has not changed with respect to, I think, all the 5 French constitutions. So although you have had, but then if you look at other democracies, or if you look at the history of other constitutions, like the history of the erstwhile communist or the communist bloc countries, let's say countries in the Eastern Bloc of Europe, Romania, Hungary, I think changing their constitutions after the revolution, and completely shifting from, where they started in 1940s and 50s, with a very communist constitution, and then changing into something very different, and now I guess becoming something very different, like Poland changing completely. I guess that is a sort of a complete constitutional shift, which is a different thing. But I guess in South Asian context, if you look at it, Sri Lanka has had 2 or 3 constitutions, I think, and they have sort of revived, or they have maintained to an extent, I guess, a basic structure, but not necessarily in many contexts, like presidential powers have changed or over the period of time in Sri Lanka. I think we need to kind of reflect on that note. But constitutionalism, if it is in some spirit is working, I think, beyond the constitutional changes, I think that is exactly what is needed, perhaps if that is not the case, then there is a problem, I suppose. Yeah, thank you.
Thank you, Professor Mandel. It's been a great conversation, I must say, and we have so many questions. I really apologize to the audience that we won't be able to address on the panel, but I do request you to send these questions to us, and we'll request the panelists to, address them separately, and we'll be sharing these answers. So we'll be sharing our email address. Do write to us so that all those questions can be addressed. Thank you again to the distinguished panelists for such a great conversation on such an important event and day. Since its inception, we at LSAC believe that the legal profession should reflect the ever-changing diversity of our society. Because of this belief, we also make sure that there are resources available to promote a broad-based diversity in legal education and across legal professions. Our goal is to support the evolution of India's unique legal ecosystem, and this is what we've discussed in today's webinar. To this, I would actually like to highlight that we've started our registrations for the LSAT India 22 examination. It's open for the January and the main admin. Do not miss the opportunity, because we're also giving a certain early bird discounts for registering before 15th of December. We're also offering practice papers in the form of LSAC Law Prep, which offers first time and repeat test takers the means to practice the LSAT India for any competitive law entrance exam. And the reason I was telling the students and the audience members to stay till the very end of the webinar is because we are offering a 15% discount only to the participants who have registered today for the webinar. So please ensure to drop in your name to the email address given in the chat box. Thirdly, I would also want to introduce certain student-focused initiatives we have taken, that is a student ambassador program, the Justice League program, and an upcoming moot court competition we are going to conduct for law aspirants in the month of February next year. So I request the audience again to ensure that they keep on visiting our Discover Law website for more information. Once again, I thank the panelists for taking out their time from the busy schedules to motivate the law aspirants today. I also thank the audience for their active participation and the LSAC team for the successful conduct of the webinar. Last but not the least, I would like to state that on this Constitution Day, let's have a collective commitment to the values of democracy, rule of law, and constitutionalism as enshrined in the Constitution of India. So see you soon on another effective and interesting webinar we'll be offering in the upcoming months. Till then, I would say stay safe and stay healthy.
Thank you.
Thank you all. Thank you all.